Family disputes can make us feel isolated and vulnerable. Maybe you're going through a divorce or a legal dispute about your kids. Perhaps you've spent hours on Google or have even posted anonymously on Facebook to see what others have to say. But are you getting the actual information and support that you're looking for? Our podcast, Legal Lounge, aims to dispel misinformation and downright bad legal information to empower anyone with questions about their family, their children, their finances, their marriage, and the law. As a team focused exclusively on family law matters, we aim to help listeners not only with the information they need, but also with the hope that their situation has a solution. Short disclaimer, please note this podcast is for educational purposes only, and the information should not be relied upon as legal advice or for legal purposes. Hi, Greg.
Hi, Theresa.
It's so wonderful to have you here on Legal Lounge. Thank you for joining us today.
Oh, it's an honor. Appreciate you having me here.
For all the listeners, can you tell us a little bit more about what you do and your profession?
I'm a forensic accountant. Most people say, what is a forensic accountant? And I say, well, we look for dead numbers. And they look at me kind of weird and I smile.
Dead numbers. I like that.
I've been a CPA for, over 40 years now. I've audited companies' financials, done all kinds of tax work. And when you're auditing a financial statement, I call it sort of shotgun assurance. You're sort of looking at a broad aspect of all the financial information in the financial statements that you have. In forensic accounting, you don't do that. It's more of a rifle approach. You look specifically at certain things that you think might be problematic, and you dig underneath. And I tell everybody all the time, the truth is in the numbers. You just have to get underneath them and find out what the real truth is. And in my experience, unfortunately, most financial information that I'm provided that's not been audited by a CPA firm, it's not reliable. And you have to dig underneath it all and fix it.
So when you say CPA, did you actually serve as like a tax accountant for any part of your career?
Partly, yes. I did it all.
Okay, yeah.
I audited financials. I prepared business and individual tax returns. I did business consulting with business owners. I helped them buy and sell businesses. I did strategic planning with them. I think about everything you could think a CPA could do in their career, I think I've mostly done.
And then you founded your own forensic accounting firm.
Yes.
And when did you do that?
Well, back in Alabama, I was in Alabama most of my career. I moved up here in 2015, but I formed a firm in 2000, and I had started doing this kind of work in 1998.
Okay.
And gradually over time, it just became the bulk of my work. And when I moved to Charlotte, I dispensed with all the traditional CPA work. No more audits, no more tax returns, no more tax season. All the work that I do now is generally litigation driven. Every now and then we're doing something for someone who wants to know the value of their business, maybe for a potential sale or, things of that nature. But I'd say probably 95% of our work is some sort of litigation.
So you decided to join us in the trenches, in the courtroom.
Oh, yeah. Yeah. It's not for the weak at heart.
Yeah, exactly. So what kind of made you make that decision?
I guess it started when this thing started for me. Attorneys that I worked with clients, one of them called me one day and said, hey, can you come to my office and help me figure something out? So I did. And the next thing I know, I'm in court testifying as an expert witness. I'd never done that before, didn't have any training in it, had no idea what it was. So that's where it started. And I didn't really decide to do it. It just one led to another, to another, to another. And the more I did, the more I got called. And I just, I was just doing so much of it that it was hard to keep up with everything. In our profession, everything we do has rules.
Sure.
We call them professional standards. So auditing has standards. Tax, we have tax law. We can't do anything really without having some sort of a rule for how you're supposed to do your work. So to be competent in all of that all the time with all the changes can be really challenging.
Well, you're talking to a lawyer, so I get that. Rules change all the time, and so you have to keep up with things to stay in the know.
Well, you do. And in the legal world, it's not just the statutory law, it's all the case law.
Yeah.
Every time a case goes to the Court of Appeals, you have new things that you have to be aware of.
And so when you say litigation, what areas of law are you an expert witness in, or what do you focus on?
Well, it's pretty broad. Fraud investigation. I've testified about fraud to have people prosecuted. I've testified on a defense perspective, civil damages, contractual disputes between people or companies, personal injury damages, just general forensic accounting. What does these financial statements really mean? And a lot is business valuation. I would say probably at least 60% probably of our work has some aspect of business valuation to it. You can have a shareholder dispute. You can have shareholders that are being pushed out, shareholders who want to buy in, divorces, obviously.
Yep.
Even in damages, sometimes the value of a business is driven by the change in value. What was the value before the event? What's the value after the event?
Okay. And so, I'm going to bring you now into my arena, the arena that's not for the faint of heart, the family law arena. So when would you get involved in a divorce or property dispute?
We prefer to get involved early.
Sure. Yeah.
The sooner we're involved, the more helpful we can be. Unfortunately, oftentimes, we're not retained until way into the process. Discovery has been ongoing for a long time. We get retained and they say, what do you need? And suddenly we need all these documents that they have not thought about.
Sure. And so I guess for the average listener, you get involved when parties have already, say, started the complaint for equitable distribution here in North Carolina, or the complaint for maybe even spousal support issues.
Yes. Okay. Sometimes we're retained, before the complaints are filed.
Okay.
Sometimes parties are trying to settle out of court. And in those cases, usually we're jointly retained by both attorneys.
Okay.
And we're a neutral expert. I've been fortunate to build a reputation that we're not biased about what we do. We try really, really hard. It's, we're human beings. And when you're working for one side, you hear one side. You don't hear the other side.
Sure.
And you have to be careful to balance that and consider things that might not be in your client's best interest.
Yeah.
Because my duty is to the court, not really to the client who's hiring me.
Fair enough, especially as an expert witness.
Absolutely.
Because you're going to be presenting information that the judge simply doesn't know about.
Right. And as an expert witness, all I have is my credibility. And if I do anything that lets that be tarnished, then I lose value to the people who've hired me. I lose value to the legal process, and it hurts me personally. So, I work hard to protect that.
Yeah, and let's come back to what you stated a moment ago, that the numbers just don't lie. They're on the statements, and if you can track them, they're pretty straightforward. However, how you analyze them can get tricky.
I say numbers don't lie, but oftentimes the financial information that I'm given is not correct.
Okay, and what do you mean?
Small business owners keep their financial records. Most of them do it the best that they know, but they're not accountants. Mm-hmm. They don't really understand generally accepted accounting principles. Unless you're a CPA, you don't, in my experience. Generally accepted accounting principles help you create financial statements that are reliable. And so if you're not doing that, then whatever you're given is not reliable. And so that's where the forensic accounting comes into play. You have to start analyzing those financials, getting underlying information. What's underneath the financial statements? You have ledgers. We always want to get the general ledger, because the general ledger lets you see what's going on. In many small businesses, you don't just have business expenses in the business. Sure. You'll have personal expenses or, things that you have to take consideration of in valuing the business. Business valuation is pretty complex. It's simple, but it's very complex.
So you can't teach us the whole course on this podcast?
No, I can't teach you the whole course. It's all about what do you think is going to happen in the future?
Sure.
And that requires professional judgment that's seasoned and well-honed.
Building relationships is a natural part of life. But how does the law affect those relationships? Do you want to marry your significant other, but have cold feet from the many divorce horror stories out there? Are you preparing for a custody battle against your ex? That is where Modern Legal comes in. We offer education and knowledge about the law when it affects the relationships near and dear to your heart. To learn more about how family law affects your family, book a consultation with an attorney of our Modern Legal team by visiting our website, emailing us, or calling us at 704-286-6302. Check out the information about Modern Legal Services at modernlegalnc.com. And so let's say you are retained for a property division as a result of a divorce, and there is a business involved. What are the steps? Like, take us through the process of how you get involved, what you may be asking for or looking for, and then how you influence the attorneys and the parties to either hopeful settlement or you're going to be showing up in the courtroom.
Yeah, we when we're contacted, the first thing we do is we ask for the complaint so that we can understand what the issues are. Sometimes, you want the answer as well, so you see both sides. We'll prepare an engagement letter contract with the law firm who retains us, because we're always retained by the law firm so that our work is privileged until we release it. Then we prepare a document request list. We need the articles of incorporation, organization. We need the general ledgers. We need the financial statements, the tax returns. We need contracts, lease agreements, contracts with third parties. Sometimes businesses have related companies and their transactions with those companies, and we need to see those contracts to understand what's going on. We need to understand owner compensation. I can make you a long list.
Sure.
I'm sure you've seen them before.
Yeah, well, I've worked with you before.
So, yeah,
I get it.
So we start there, and we always want the general ledgers. Mm-hmm. And sometimes the opposing, let's say that I'm working for the non-business owner party. The business owner doesn't really want me to see everything if there's things to hide. And so they'll resist.
Sure.
Sometimes you have to have a motion to compel production.
Yeah.
So we work with the attorneys to let them know what we need and why we need it. We talk with them about what we're seeing. Usually we write a report. And the way that I do my work, I try really hard to demonstrate why my work is right and why a different approach would be wrong. And that usually helps in a settlement. Litigation is so expensive. Going to court is enormously expensive for the parties. Mm-hmm. So if I can help bring a resolution prior to that, then I think I've helped the process.
Sure. I mean, especially from the legal side, the attorney side, I'm not an accountant or a CPA. I am not trained in analyzing financial statements. And I mean, even though I run my own business and I try to keep up with my own QuickBooks and my own ledger, of course, to your point, every business is a little different. And so from my perspective, knowing what the numbers are really reflecting from both a value of the business, but as well as positions from both sides, helps me then create those legal arguments in the courtroom or in negotiations as well to help influence a better outcome for my client.
Yeah, one of the most important things I feel like I have to do in these cases is educate the attorney who's retained me about what I know and why it's important. So if things don't settle and we go to trial, I generally prepare a Q&A.
Yeah.
Here's how you need to ask me questions to get my testimony out, and here's why it's important. And then the attorney has the benefit of at least knowing what it is I'm trying to say in court.
Yeah.
And when you're cross-examined, and usually if it's a really good cross-examining attorney, they try to confuse things.
Sure.
And so then the attorney has information that on redirect, he can come back and try to fix any confusion that came in.
Yeah. Have you ever had a case where, you've been retained by one side, it is going to the courtroom, but then the opposing side hires their own expert?
Yes.
And how do you prepare for a court matter where it becomes like a battle of the experts? And when I see in my mind, I always think like two gladiators coming from their respective sides in the arena, going at it with their knowledge, not a sword, you know what I mean? But like, how do you prepare for that?
Yeah, sometimes it's that way.
Yeah.
We always want to get their report,
and
we want to read it and understand it. And to the degree that we think that they've made mistakes, we point those out and prepare the attorneys, for why the approach we've taken is correct and why their approach is wrong. In some cases, let's say that I'm representing the non-business owner and the opposing expert is representing the business owner. Sometimes they have information I wasn't provided, and that information can impact my opinions. And so I will update my report with this new information, regardless of what it does, because it's factual evidence.
Sure.
So it should have been provided to me in the process, but sometimes
you got to work with what you get.
That's true. You do.
Yeah. So when you're involved in these cases, as you point out, you have to educate the attorney, but there's also the judge, and it's it's my experience that judges may not know that much about a family law case while they're presiding over a family law case. Take it to one step further, they might not understand your field, the accounting field, the forensic accounting field. How do you handle that?
It's really challenging as an expert because I know the rules. I know how I'm supposed to do my work. I know that if the other evaluator has done his work right or not. Getting the judge to understand that can be hard. Mm-hmm. One of the things that I see that troubles me a lot is this thing called known or knowable. That on the valuation date, let's say that I'm valuing a company as of June the 30th of 2023, and I'm in court sometime in 2024, and the opposing valuator used the 2023 tax return, which includes July through December information. Well, that wasn't known on June the 30th. So you can't use that information. It's tainted. But getting the judges to understand that can be hard because you have two arguments going on.
Sure.
And then the judge has to decide who they're going to believe.
Yeah.
That makes it hard for them. It's unfortunate in our profession. You would think that good, competent valuators having the same information to look at could value businesses and come somewhere close to each other. Mm-hmm. And I've had that happen frequently. There are good valuators here in the Charlotte market that I respect, and usually our numbers aren't too far off. They'll always be different in some way. But I have cases where they're like light years apart. Mm-hmm. And then what's the court going to do? I have a really good friend, Jim Hitchner, who writes books about valuation. He's been doing this longer than me. And he was doing a judges panel once. And he was talking to the judges about being unbiased and that sort of thing. And one of the judges interrupted him and said, Jim, when you walk into my courtroom, I have already decided that you're biased and the other party's biased. I have to determine which one is the least biased.
Sure.
And I thought how sad that is that in our profession, we're bound by the federal rules or the state rules of evidence and procedure. We have professional standards about confidentiality, being unbiased, being objective. And yet, over and over and over and over, valuators who are experts to the court and are admitted as such sometimes aren't.
Yeah. Well, and we on the evidence training side, when we're in law school, for example, we are trained about bias, right? So, for example, if my client asks, well, can we call my mom to the stand to testify how good a parent I am? I usually respond and say, well, yes, your mom would say that because they are biased. Being your parent, you are the best child on planet Earth. Therefore, you're the best parent on planet Earth.
Right.
On the flip side, the judge knows that and may not even listen to your mom if they're on the stand. And that's why maybe we don't call your mom as a witness. However, a teacher or another professional may have a slightly less biased perspective. But to your point, a judge does recognize that if one side calls anyone, whether it's an expert, a counselor, a teacher, because that side is calling that person may already be biased to that party's argument inside.
That's true. On the concept of bias, I'm a member of a lot of national associations, and I speak from time to time. And so I was out a couple of years ago speaking at the National Association of Certified Valuators and Analysts annual conference in Salt Lake City. And I had a co-presenter with me, and our topic was, how can you be unbiased and objective as an expert witness in litigation? And we brought out the factors of how we're biased. And then how do you mitigate that bias? There's things you can do to eliminate bias in yourself when you're making objective, important decisions. One of the participants in my session was a valuator up in New York that I know, and he liked our program so much that he and I are going to be making the same presentation to the American Institute of CPAs at some point in the future, because it's so important as experts that we know that we can be biased and we work hard to eliminate it before we form our opinions.
Yeah. Well, and that's the goal, right?
It is.
You're trying to present quote unquote pure information to the decision maker. In family law, that's the judge.
Yes.
And, we want to, especially as an attorney who's called expert witnesses, we want to present good information to the judge.
Yes, and it's important to talk to the judge.
Yes.
We're up in this little box usually.
Yeah.
And the judge is usually over my right shoulder, sometimes up high. I don't know, it depends on what courtroom you're in. But I try to when I'm asked a question, I try to turn and look at the judge and get them to look at me and listen to me as I explain things, because they're the decision maker in a family law case.
Yeah.
If you have a jury, then, you look at the jury and you try to talk to them.
Yeah. So let's back up from being in the courtroom. We're in the courtroom enough. So if anyone has questions about that, please let us know. Leave comments. How about if a person is in the state of deciding whether or not they even want to separate, and they haven't even started the true process of dividing financials and dividing property? What would you advise to someone thinking about that process, especially from your perspective as a forensic accountant?
We get calls like that at times, and the first thing I do is I say, you need to get a really good attorney to help you understand what you're facing potentially with this, because it is a legal issue. So I will, recommend, 2 or 3 people that I think would fit with what that person needs. Some people are in very complex situations where the opposing spouse owns a large business that's extremely complex, and you need an attorney that can really understand those things.
Yeah.
And in some cases, you don't have that, and you don't have that requirement. So I try to help them find that.
Which I appreciate, because I think a lot of people almost want to avoid talking to an attorney until they quote unquote need to, not realizing you need to as soon as you even think the question.
Well, you do, because, we're all human beings, and this whole divorce process is so emotional that a party can, without realizing they're doing it, do something really damaging, to themselves in the process with something they say or something they write.
Sure. And
then you can't unsay or unwrite that.
Very true. I literally was in a negotiation recently, and let's just say one party got a hold of certain messages that weren't even sent to that party. And it was used as we'll bring this up in a courtroom if we need to. And I'm sitting here, that's objectionable because, privacy laws apply, wiretapping laws apply. But at the end of the day, my client, the person who sent it, couldn't take it back.
Right.
And it's already on the table, which then leads to certain concerns and suspicions on the opposing party's part. Valid or not, it does frustrate the process.
It does. And what I've observed with judges who don't really understand financial matters and business valuation, they tend to pick a side.
Sure.
Who is the most credible party in this litigation? Who seems like they've behaved the right way, the best way?
Yeah.
And then they don't really think as much as they should maybe about some of the other things, I think.
Yeah.
And they just go with the person that they think is the most credible of the 2 parties.
Yeah. And credibility is huge in a courtroom because,
it is.
In a way, both parties may be saying their truth. I joke with my clients. I'm like, yes, there's your truth. There's the opposing party's truth. And then there's God. But unfortunately, he's not willing to testify. So if we really want to present our case to a judge, recognize that a judge may believe more truths from one side than the other, which gets tricky because, that isn't true, but how can we prove that it's not true?
Yeah, I've seen one case where a judge decided that one of the parties was not honest in the testimony given, and it just changed everything.
Sure.
That's the one thing as a witness, as an expert witness, I have to tell the truth.
Yeah.
Whatever it is, because that's my job. And I think as a party, it's important that they know they need to tell the truth, whatever that truth is. Even if it might hurt you, it'll come out best for you.
Yeah. Yeah, I agree completely. Wow. It's hard on my side sometimes for my clients to recognize the reality of what will happen in a courtroom until they've actually been through the court process.
That's true.
And no one leaves a courtroom excited or happy, right? And even if they feel like they have won, they're not ecstatic about it because at the end of the day, in my field, it means that, that a divorce has occurred or children have been divided between 2 households or that there's simply a failed relationship. And the more realities that we can, or more information about those realities that happen in a courtroom to people who may be listening to this podcast or posting questions on Facebook or posting questions to whatever other forums and asking questions of their family members. I think we're at the stage in society that we can influence change where our family law matters are not necessarily addressed always in a courtroom because of what you and I are discussing. And how can we shift instead to more resolution outside of a courtroom?
There's a big move for collaborative divorce, for settlements. I think in most of the cases I work in, the attorneys really on both sides, I feel like, work towards settlement, prior to trial. There's always mediation, and sometimes mediation works, but often in my experience, it doesn't. And that may be because the work we do maybe is more complex, more high dollar divorce cases, and the parties have a lot of money and they're willing to spend it, to try to win, which is unfortunate.
Yeah, to try to win. I like to emphasize this, to try to win.
Yeah, it's, I have my own pet peeves about the work I do because I'm just one voice in the courtroom.
Yeah.
And my job is to be objective.
Yeah.
And the attorney's job is to be an advocate for each party.
Yeah.
It's about winning.
Yeah.
It's not about the truth. It's not about evidence. Getting evidence in cases sometimes can be real challenging.
Does that happen often?
It happens in high dollar, it's been my experience, high dollar divorce cases where there's a lot of money at stake. The business is extremely valuable. I'm talking multi-millions of dollars.
Yeah.
And the business owner is willing to spend the money to try to win.
Yeah.
That's what I've observed anyway. It's not always the case. There are good people out there that go through divorces and, they do things the best they can the right way. But oftentimes that's not the case.
Yeah.
And when that happens, I'm sorry.
It's okay.
It's enormously expensive, to the party that doesn't own the business.
Yeah.
Because that person's having to pay us, having to pay the attorney.
What are ways that you can help parties outside of the courtroom when they're negotiating in your role as a forensic accountant?
I think the best way we can help is if there is a mediation, let me go to the mediation. Let me talk to the mediator, perhaps talk to both parties.
Sure.
Let them see that, we're not biased for one side or the other. We're trying to help them understand the facts and the truth. We can be very effective in doing that.
Yeah. When you get involved, say, in a negotiation process and one side, the business owner, is not willing to provide as much as you may need, say, to testify in court, can you work with a smaller subset of documents or information? Or do you want to say, well, it depends, and that's really hard to figure out?
No, I've told people before I've had to testify with one hand tied behind my back.
Yeah.
Because I couldn't get all the evidence I needed. We had a really difficult case where there was a lot of fraud in it. And I think this is something important for the attorneys who might be listening in.
Yeah.
When I am designated as an expert, a document is prepared that goes into the court. It's an expert designation, as you know, and it stipulates what I'm expected to testify about. Well, in this case, one was prepared, and it was submitted to the court. Well, we get in, we do our work. We work for a year or two, whatever that was, and we find what we believe are fraudulent transactions. And so we prepare a presentation, go into court, to explain this to the judge because we're trying to get information that we don't have, that we need. So the attorney puts me on the stand, walks me through my credentials, offers me as an expert. The opposing attorney objects that I'm going to be testifying to potential fraud, and the designation didn't address that. So an argument erupts for about 30 minutes while I'm sitting on the stand.
Of course, between the attorneys, and I guess imagine the judge as well.
Yep, that was it. The judge has them send her, in this case a female judge, the designation. She gets it, she reads it, and then she turns to me and says, "Mr. Reagan, this designation does not say you'll talk about fraud. I can't let you testify." And the sad part to me is that when we're hired and we start, we don't expect to find fraud.
Yeah.
There's not an expectation that the attorney would draft into my designation that if we find fraud, we're going to talk about it. It seems like, why would you put that in there? But in this case, had it been in there, I could have testified. We could have probably gotten the documents that we really needed to prove the truth. But in this case, we couldn't. And so I had one hand tied behind my back. I had to do my work with what I had and do the best I could with it.
And so when that designation is entered, it can't be adjusted, or?
I've heard that it can, but in some cases, the judges don't let them do that.
It's just too late, which comes back to what we were discussing earlier. It's rough in the courtroom. And there are just some things that happen in the courtroom that may not make logical sense or may not seem fair. But I do also remind my clients, I'm like, what you think is fair is not necessarily the goal of the courts. And judges are bound by certain rules and procedures that, yes, don't make sense and are not fair.
It's true. They have a tough job, and
they have a very tough
and they're
job.
Individuals, and individuals make different decisions about things.
Mm-hmm.
So one judge might let something in, another judge might not, and that's unfortunately the way it works. I've had one case where we're in the courtroom testifying, and in this case, it was a prosecuting attorney for the state introduced new evidence that hadn't been introduced, and there was a big argument about whether it should come in or not. Well, what happened was the judge decided to let it in, even though it was past the discovery deadline. And she had me come into her into her chambers and work in a conference room for 3 days, reviewing all of this new evidence.
At the last minute.
Yeah, it was in the middle of trial.
Oh, my goodness.
And so she interrupted trial. I came to her chambers. I worked in a conference room for 3 days, reviewing all of this new evidence. And then I came out and they put me on the stand again, and I testified to it.
Wow.
So you never know. I think one of the best things I've ever heard a mediator say, I participated in mediation a few years ago. And in this case, everybody was together in one room at the beginning, and the mediator was talking to both parties and everyone there. He said, today is your last chance to have input in the outcome of this matter. If you don't come to an agreement today, you're going to turn this over to someone else that you don't know, and they're going to make the decision for you, and you're going to live with it whether you like it or not.
Yeah.
I thought that was really good advice.
Yeah.
And it really does help people if they think that way. They realize I have a chance to have a say-so about this whole deal. And if it's totally unfair, you don't agree.
Yeah. Mediation is, I'm a certified mediator. I've done arbitrations as well. And I agree wholeheartedly with that statement. What I think a lot of individuals going through the divorce process may not understand is if you want your day in court, you don't have direct control over the outcome.
Do not.
The judge does. And your attorney can influence the judge, and your testimony and your evidence and everything you present definitely will influence the judge, but influence is not control.
That's correct.
And at mediation, you still have control over some of the outcomes.
It's true. It's a good thing for people to think about. And again, because it's so emotional, it's hard sometimes for a party to back up and just think about it rationally, because sometimes you're not rational, when you're in the midst of an emotional dispute like that.
Sure. I would argue probably 99% of the time you're not rational. And that's okay, right?
Yeah, it's hard.
There have been studies that indicate that the loss of a marital relationship is similar to the loss of a loved one who's passed away. And when you're going through that level of grief and that trauma, if you will, no one can think straight. We literally, whether we like it or not, we're a bunch of chemicals and water and all this other stuff. And there are certain things we can and cannot do no matter how intellectually smart we are and no matter how in good health we may be. Yeah. And that's really why you do bring in attorneys and experts to help you through this process.
It's so true. I heard a pastor once say that in every marriage, there are 3 parties. There's the husband, there's the wife, and there's the marriage.
Yes.
And so that marriage is like a person, an entity. Mm-hmm. And when it dissolves, it has died.
Yeah.
And that has an effect on everyone. The 2 parties, the children, family members.
Yep.
Yeah.
And the ripple effect. And then if you have business owners, the business, any business partners, the employees, the teams.
Yeah, it's a hard process. It's necessary at times, but it's like most things in life. There's a right way and a wrong way to do everything.
Yes.
And trying to do it the right way can be challenging.
Yeah. I know a lot of people who have either asked me questions, via email, via modern legal social media platforms, or even directly during consultations. They almost expect a clear cut, okay, how do we do this? And I've done this for over a decade, and you've done it for a little bit more than that right, in your wiser years. And there is no one way to handle any separation, divorce, or division of property or custody disputes.
There is not. Everything is unique to the specific parties involved. Even in valuing, if you were going to value two businesses that were the same, two restaurants or two consulting firms, they're different. They have different customers. They have different vendors. They have different personnel. They have different objectives, different policies and procedures of how they operate. There's just not a canned way to do that. And every marriage is different. The people are different. So it's hard because you don't have a canned approach.
Yeah.
You have to try to be creative and innovative and think through the best way to do your job.
Yeah. And coming back to the emotional point, there may be, and I know I get like this because I'm a very much a legal thinker, a nerd, if you want to call me that. And I always think of this is what would happen in court. And I say that with some conviction, knowing that a judge very well could disagree with me, and I understand that. But, there's certain cases, there's history, there's, my experience and the experience of other attorneys I've worked with. And I get almost tunnel vision sometimes in saying, okay, if we don't agree to this because this is the law, then we're not going to settle. And I know attorneys can share in that sentiment. However, we also, as the legal practitioners, have to reflect and say, okay, just because we know we may win something in a court case, we have to take a deep breath. I guess that's the very first step. But then second off, really turn to the client and figure out, what do they want? What do they want in the end? And I have been at mediations, more than one, where I will sit with the client and indicate to them, look, this is what I think wholeheartedly we can get in a courtroom. This will be your bare minimum. Maybe it'll be higher than that in a monetary value, but it may take us a year to get there. It may take us more than a year to get there.
Yeah.
And between now and then, yes, you're going to have to pay attorney's fees. You may have to pay expert fees. You may have to just deal with this lawsuit hanging over your head, the emotional, the mental toll that takes is something to be accounted for. And I remember one mediation specifically, I said to my client, who was a female, I think I called her Honey, I said, honey, we could easily get another $100,000 if we go to court. But what is your mental health worth to you? Have you been able to sleep through a full night for the past 6 months?
That is unfortunately, because the work we do, we work with all kinds of people. We work with business owners. We work with a non-business owner. Sometimes we're working for all the parties in the business, depending on the facts and circumstances. But in a divorce matter, when we're retained by, let's say, the wife who doesn't own the business, some of the business owner gentlemen, you've lived with each other for a long time. You know the hot buttons. You know the weaknesses and strengths in one another. And I've seen men who own businesses just drive this out so long and so hard because the women and men are different. The women are concerned about the children more so. Not that men aren't concerned. I have children. I love my children, I think as much as my wife, the mother of my children. But there's still a difference. We were made different.
Yeah.
Women are more nurturing.
Yeah.
And so generally women want this over and they want to get on with their life. And some men know that and take advantage of that and just push it and push it and push it, make it more and more expensive, harder on them. And there are times that, that the women need to just stand up and bear it longer because the settlement that's on the table is not fair.
Yeah.
Sometimes they do that. Sometimes they cave because they need to move on with their life. It's this is a hard business.
Yeah. And every resolution, whether that be voluntary or forced upon you by a judge's order, does create almost like an ending of a chapter, right? A turning of the page. And so we come in as professionals in this field to help our clients. But like I tell a number of my clients, I'm not steering the ship. You are. I'm here to help you as a navigator, right? I have the compass. I have this knowledge. I have a lot of information about this specific judicial ocean.
Yeah.
Right. But at the end of the day, every resolution for a specific individual will not only be unique, but maybe different for each person on how, they feel that's fair or unfair or right for them.
It's true. These are hard things for people to have to decide, when is enough?
Yeah.
When do I think this is the right thing to do? I was personally involved in not divorce, but a shareholder dispute issue. And my former partners did some things that I thought were wrong. They were hurting me financially.
Which a shareholder dispute is a lot like divorce. Let's point that out.
Oh, absolutely. It can be very much so.
Yeah.
And I went to an attorney and talked with him and provided him the evidence. And he said, Greg, you're going to win if we go to court, but it's going to cost you more than you're going to get in the settlement. He said, sometimes you just need to move on with your life. And so that's what I did. I put it away and I moved on and I didn't look back.
Yeah.
Sometimes that's what you need to do in a divorce. You do the best you can to get a fair resolution. You generally don't think it's fair, whatever it is.
Sure.
But at some point, you have to think about your life and the rest of your life and moving on. And there's value in that.
Yeah.
The longer this thing drags out, the harder it is on you. And mental health is a concern.
Yeah. So you were talking about the collaborative law piece very briefly, but what is collaborative law from your understanding?
Well, I actually understand it really well. I went through my own divorce.
Okay. Yeah.
I chose to end a long-term marriage and we decided to do the collaborative approach. And so I hired my attorney. She hired her attorney. A neutral financial expert was brought in and a counselor was brought in. Mm-hmm. And every meeting we had, we were all there. All of the evidence was on top of the table. Anything that she wanted to present, I saw. Anything I wanted to present, she saw. Both attorneys, everybody saw everything. It's really I think it's a fair way to do it if the parties can be amicable with one another.
Yeah, it's very therapeutic.
It is very therapeutic. And the fact that you have a counselor there to help you work through the emotional things, it doesn't fit every single divorce, but if you have parties that are not wanting to kill each other,
fair,
not physically, not literally, but emotionally, and just do whatever it takes to win, whatever win is in their mind. If that's not the case, collaborative can be a good approach.
And so when there is a collaborative process, you bring in any experts that are necessary to help the parties work through those issues. And that may mean you meet on more than one occasion, right?
Yes, you meet often.
Mm-hmm.
I think in my case, I don't know how many meetings we had, but we had several. Several
meetings. But the whole goal is not only to be fully informed and have everything on the table, but also to, as parties started a marriage together, they end the marriage together, and literally discuss how to bring a finality or, a turning of the page to that marriage.
Yeah, one of the interesting parts, at least in my case, was a meeting where it was an opportunity for each party to say what they wanted to say to each other. And it's a little maybe embarrassing or difficult because in my case, there were 4 women in the room.
So you're only the guy in the room.
My wife at the time, 2 female attorneys and a female counselor, and me.
Yeah.
And I'm to say whatever I want to say to my wife about, how I feel, about the marriage and what went wrong. And, and so it's extremely vulnerable. At least that part was for me. And then, she was able to say whatever she wanted to say, in the same way. But the purpose of it is to try to help you bring closure. Mm-hmm. And so I think for me, it helped me. I can't speak for my ex-wife,
sure,
how she felt about that, but I think it does help. And I think it's a way to protect the children.
Yeah.
Oftentimes, in my case, my children were all older.
Yeah.
And they had watched, whatever dysfunctionality was in our relationship,
Yeah.
they'd seen that throughout life. And the kids, they see all that.
They do.
They're affected by it all.
Yeah.
And it's collaborative really protects them, I think, because in a divorce that's not collaborative, oftentimes the children are used as pawns to win.
Yeah.
And that's the sad part.
Yeah. I hear that a lot, that the ultimate victims of a really bad divorce are not either party, but generally the children.
Yeah, I've seen that often.
Even if the child never has to be brought into the courtroom or otherwise interact with the legal system, they feel the tension from their parents. They observe the arguments.
Well, they do. And sometimes, one parent tries to dissuade the children from liking the other parent. And, children need both their parents to grow up healthy and well-balanced in life. And all of us are human and none of us are perfect. And, I think most people try to do the best that they can, as being a parent. And so when division is brought in and one party tries to make the other one look terrible and say really ugly things about them, that really hurts the children.
Yeah.
So, that was what I liked about collaborative was I didn't want my kids thrown into the midst of this. This was something between the two of us in our case. It needed to be resolved between the two of us, and we needed to look out for the best interest of our children.
Yeah.
I wish all parents would do that going through divorce.
Yeah, more so.
Yeah.
Well, we do the best that we can, in your words. Well, Greg, thank you so much for joining us today. I appreciate you being here. Your information, I'm sure, will be valued by a number of listeners. And we'll probably have you back one day.
That would be great. Thank you, Theresa.
Thank you for taking the time to listen to our discussion. To learn more about me and the Modern Legal team, go to our website, modernlegalnc.com, or check out the links in our show notes to follow us on Instagram, Facebook, LinkedIn, and YouTube. You can also call us at 704-286-6302. If you have been intrigued by the conversation and would like us to continue our discussions, please subscribe to the podcast and leave us a review. See you next time.